Although positive law has contributed immensely to the development of the legal system of all the countries in the world, its detriments or its shortcomings cannot be overemphasized. And in today's video, we are going to consider the criticisms that has over the years surround positive school of law or legal positivism school of law, or you can call it the legal positivism jurisprudence if you like. This is our last video as it concerns positive law. We started by the concept analysis of positive law. From there, we proceed to the types of thoughts that exist under positive law, where we identified the imperative theory under the second video. Then on the third video, we identified a Kelsen theory of ground norm, or what many regard as pure theory of law under the legal positivism. Then also lastly, on this fourth video, we are considering what are the criticisms and then the advantageous part of positive law, because definitely everything in this life, especially as has to do with theories of law, must always come with its shortcoming and its strength. And that is what we are going to consider today. Number one argument, which over the years has surrounded positive law, is the fact that it tends to separate law from morality. Positive law takes a bold step always to alienate law from morality, and such has been a heavy criticisms that surrounds positive law. Because John Austin, if you have followed us in our second video, yes, if you have followed us in our second video where we discussed the perspective of imperative theory, we see that John Austin attempted or even tried to alienate law totally from morality. According to him, whether law is right or not right, what matters is a command and is backed by sanction and is proceeding from the sovereign. Once these three conditions has been met, that law should be obeyed. But natural law say no. Lest injust stand on lex X. An unjust law is not law at all. You cannot tell me that Mr. President can wake up one morning and declares it at home and everybody must obey. You cannot tell me that Mr. President can simply say because he's passing, nobody should go, nobody should move out of the metropolis because the governor is passing, everybody should obey. That is against the right of freedom of movement, which ordinarily is guaranteed by nature itself. That is the idea of natural law. But the positive law say, see, regardless of whatever you are saying, provided that this is a valid law, provided that this is coming from a sovereign, provided that this vibes the idea of sanction and command, you're on your own. This is law, regardless of anything. That is a criticism. Positive law tries to alienate law from morality. In as much as we always endorse the idea and make the assertion that law is different from morality, there are still contaminants. There are still contaminants in nature. They are not totally separated. Though they work, there are two poles apart, but in one way or the other, there are still contaminants. They flow with each other. And trying to make it otherwise will encourage what happens in the era of Adolf Hitler. Of course, you have heard about Hitler, right? Hitler was a man that was perpetuating injustice. The law he made, he was dishing out law that was against the masses. And nobody could invalidate the law based on this idea of positive law, because the man was busy dishing out law. Of course, Hitler was a ruler. He commands the power, he has the authority, he has the sovereign, he has everything that necessarily has to be in place for you to say this is law. And he was doing it, and people were dying. So that's why after that kind of experience in the Germany under the rule of Hitler, the world have come to recognize the fact that law and morality should not be totally separated or alienated from each other. And that is why up to today, positive law has been criticized for being too harsh, for being too extreme, to the point that it tries to say that law is law, regardless of whether it's just or not just. It should not even come to play, provided it meets the criteria of sanction, command, and sovereignty. Then secondly, high observance of imperative theory that comes with positive law could lead to tyranny or despotism in a state. If we are to 100% agree with the advocate of positive law, John Austin, Jeremy Bentham, and what's his name of this man again? Hans Kelsen. If we are to agree with them in everything they stated in positive law, we are subjecting our country into the rule of tyranny. We are going to cause chaos in the whole nation. Assuming whatever Mr. President deems necessary becomes the law, all of us is going to bear the brunt. Assuming whatever the legislature deems necessary becomes the law, once they follow the formality of making the law, once any law they deem necessary becomes the law, it means that all of us is going to suffer it. So criticisms that surrounds positive law is that overemphasis on imperative nature of law is antithetical to the societal welfare and justice. Yes, tell your lecturer that if we are to agree with the positive law assertion, especially as it has to do with imperative nature of law, it means that the society will be subjected to anarchy, doom, and chaos, said by King's advocate. And I have my reason for saying so, because the law should be made for the interest of the society, not for the interest of the leader that is making the law. And the idea of positive law always surrounds this idea that once it is coming from the leader, once it's coming from the legislature, it is all hail the queen. You have no objection. Objection, my lord. Everything is closed and it becomes law. So if we are to agree with them 100%, we are going to suffer the brunt and all of us will not actually recover from the heat. Positive law has been eulogized for being too predictable, for being too clear. But this I'm saying concerning being fake and being rooted in abstraction has to do with the one developed by Hans Kelsen. Hans Kelsen developed this theory of, if you watch my last video last week, that has to do with the theory of a ground norm, then pure theory or normative theory, which is still under positive school of law, we see that Kelsen made a lot of analogy that is not realistic. He said that the law should be separated from morality, the law should be separated from politics, the law should be separated from anything. And we continue to trace the validity of law from one law to the other until we get to a point where we cannot see any other law. Then we assume that that one is the ground norm, the origin, the first ringo of all other laws. So because of this, we criticize positive law for being too vague and ambiguous. It is not clear. So one of the primary criticism of the ground norm is its abstract and vague nature. Critics argue that the ground norm is too hypothetical and lacks specificity, making it difficult to apply in practical legal analysis. So the ground norm is not an explicit rule or principle within the legal system. Its content is open to interpretation, leading to potential ambiguity. For example, many have argued that the Constitution is the ground norm. Many also have argued that the Constitution is not the ground norm. If you say that Constitution is the ground norm, who then manufactured the Constitution? Remember, the idea of ground norm is that ground norm is not created by anything, but it was been there. So if you say that ground norm is the Constitution, who empowered those that made the Constitution? What then becomes the validity of the Constitution? Kelsen told us that we should just assume or we should presuppose it to be the ground norm. So all those things is deeply rooted in ambiguity and is not clear. So we criticize positive law for that. And remember, I'm telling you this criticism not because you need it for your life. Yes, you don't need it. You don't need it even as a lawyer. What you need now is for you to pass your course and go away. So don't be bored with what I'm saying, because you need this thing to actually answer on your problem question or on your exam paper. There is no way you will tell me you examine each particular theory of law without providing the advantage of that theory and without criticizing it. One of my prof will tell you that whatever you see, criticize. In fact, after I'm done with my second year, I end up being criticism because I ended up criticizing everything. I'll even read the lecturer work, I'll criticize him. Yes, so that I will show him, you see that criticism we want, I will give it to you. So you cannot approach this theory without criticizing, without making your own opinion on it. That's why you need this. You have to actually dissect positive law and tell your lecturer the loopholes you observe on that very theory of law. Another criticism which is also still applied to this pure theory of law under legal positivism is that if we say that law is made up of hierarchy of norms as held by Kelsen, what about those that basically, for instance, England is a common law nation that basically has no stipulated rules. Most of their activities are governed by common law. What about the case law? What about law of contract? Can you beat your chest and tell me that this is a particular rule that governs law of contract? There is no particular rule that governs law of contract. There is no particular rule that governs law of tort. All these things are common law origin. Most of the rules that govern law of contract are cases. Most of the rules that govern law of tort are cases. Where do you then say that this is particular rule that as stated by Kelson that it follow this, it follow that, it follow this? Can you say that the judges observe all these things? No. All these contract law cases are governed by rules. So you cannot say that all the laws are traced by this and the validity of law is traced because it draws precedent from other valid. No. So many cases in contract law are rooted on common law. How then could you say that? Where would you trace the validity of a particular law? Will you trace the validity based on the fact that it was draw its precedent from the already existing one, already? Like, the whole thing is chaos. It will lead to, like, you become totally confused. So this idea does not hold water. And another thing which I've been saying on my video is, fourth criticism is that according to imperative theory, this one is attributed to John Austin, his own claim. He stated that law must come with sanction, but not all law that come with sanction. I'll give you instance. When you go to chapter 2 of the 1999 Constitution, chapter 2 of the 1999 Constitution contains what we call the fundamental, objective, and directive principle of state policy. That place are not justiciable by virtue of section 6, sub 6, paragraph 6 of 1999 Constitution. It is not justiciable. What do I mean by not justiciable? You cannot pick anything that is in chapter 2 to go to the court to enforce it. In other words, there is no sanction if there is a breach. Then, what then is the claim of us that say that law must come with sanction? Does it mean that all law comes with sanction? Or would you say that that is not law because it doesn't come with sanction? Of course, there are still valid parts of our law. They still guide our policy. And you cannot regard them as not being law because it doesn't come with sanction. That is to say, some laws doesn't come with sanction. Some law doesn't come with sanction, but they are still regarded as a law. So you see the criticisms. I've observed 4 criticisms, and you must point it out to your lecturer. Criticism that surrounds this is challenges to democratic principle. Challenges of democratic principle. Of course, under the rule of law and democracy, or democracy and rule of law are still relative terms. I mean, they are still new, in as much as they have been old. They have not been in existence. Originally, ab initio, what we have is a monarch, all this kind of rule by the king, whereby the king decree. And that was the era when this theory was developed. Now we are faced with modern day democracy, whereby power has been divided by the constitution itself. If you go to the section 4 of the constitution, it vests legislative power to the National Assembly legislature. If you go to the section 5, it vests executive power to the executive arm of government. If you go to section 6, it vests judicial power to the judiciary. Now, where would you trace the power, the sovereignty? Can you beat your chest and tell me that Mr. President is a sovereign ruler? Can you beat your chest and say that the legislature who makes the law that is implemented by Mr. President are the sovereign ruler? Can you also say that the judiciary who can interpret what Mr. President say on what Mr. President has executed or implemented, or what the legislature have written down to mean another thing, they are the sovereign? It becomes very difficult to determine where the sovereign exists. So the criticisms to the positive law is that all those assumptions of sovereignty is still not obtainable. Now, I can comfortably tell you now for a fact that sovereignty is no longer obtained with Mr. President. Sovereignty does not lie with the legislature. Sovereignty does not lie with the judiciary. Rather, sovereignty lies with the constitution itself by virtue of section 1.1. So the idea of positive law still don't hold water. And still yet, even the sovereignty that is obtained with the constitution can still be altered by the legislature through constitutional amendment. Even that, it can still be some part of the constitution. Mr. President still have the right to suspend some part of the constitution. Yes, they are constitutionally gifted in some aspects that they can overrule what is written there under the doctrine of necessity and too many other things. So all these things are criticisms. And the reason for criticism is that we are simply saying that everything they say are not valid, and we should not believe them, all the assumptions positive law has laid before us. And now we proceed to the advantage of positive law. Remember, like we said, everything that has disadvantage in this life has advantage. One advantageous factor we give to positive law is that it has made the law predictable and it has made the law clear. Remember, I alluded to the fact that it presents vagueness, but that has to do with Kelson theory. But when it comes to the general perspective of positive law, believe me, positive law has added predictability to law. Because had it been we align with natural law, that law is that which is written on our heart, It's not everybody that have common sense. There are some people that are animal. There are some people that smoke goof. They can just wake up and kill you and you will do nothing about it if you are to rely on natural law that you ought not to kill. But positive law has made it clear that if you kill, this will happen to you. And anything that is not written down will not happen. Those things that are written down will happen to you. They are the law we can see. We cannot rely on natural law we cannot see. All the assumptions in natural law that, morality varies. For instance, in the north, adultery is a crime. In the south, adultery is not a crime. In the north, drinking alcohol is a crime. In the south, drinking alcohol cannot be regarded as a crime. Blasphemy is a serious offense in the north. In the south, you can even blaspheme against your mother and they will clap for you. Who cares? So you see the discrepancies that exist in morality, and because of this, positive law have to come and settle this by making sure that that one that we want us, that particular crime that we all of us accept as a crime, let us write it down so that everybody will be aware that this is crime. Let us not leave it at the mercy of natural law that you ought not to. You should think, you should reason. Let us not leave everything to reason because some people don't have sense. Yes. So now that is a good attribute of positive law we must admit and we must give it to them. Number 2 is that positive law has maintained social order. So it maintains peace and order by prescribing accepted behavior and enforcing penalty for violation. Positive law has actually brought social order. Like it has actually maintained order in our world. Because even the so-called contract law that has no a practicable rule that governs it, over the years now, things are changing. Some states have enacted some law that governs contract. In international sphere, we have seen the law that governs transaction, carriage of goods by sea, so many other things. So assuming we don't have assuming we don't have positive law, assuming we don't abide this idea of positive law, how will we get a uniform system of rule that will govern everything we do? We see that now we just turn to a beast. It means that whatever good to you is not good to me. Whatever good to you is not good to me. All of us will live the way we want based on morality, based on what we feel. So we have seen that positive law actually brought social order and cohesion. And order is God. So I believe that even God will be proud of positive law because it has brought certainty to our law. And then lastly, positive law has ensured that there is a balance between law and morality. We criticize positive law for trying to separate law and morality. But yes, believe me, assuming we were to allow positive law to lap with morality, all of us is going to bear the brunt. Have you wondered why we have penal code operating in the north and criminal code operating in the south, where we have one nation? It's because of this idea of morality. Because assuming we allow morality to influence the law, it means that man will not be free. It means that some certain things will not, the law will be against man. Because if we are to buy this idea of morality that governs penal code to govern the South, they are going to be anarchy, they are going to be doomed. Because every typical society in Africa has their own morality. Sometimes what is morally upheld in a particular community will be what is morally antagonized in a particular community. So the marketing law for morality in its true sense is not a bad something. It is actually for our own good. Let us not confuse ourselves with morality and law. Assuming every single act provided in the Quran or in the Bible was to be made an offense, it will be against those who are not supporters of Muslim. It will be against those who are not supporters of Christianity. It will be against those who are not supporters of pagan. So that's why this idea of separation is also a good advantage to positive law. So there you have it on advantage of positive law. I encourage you, go to the playlist, click the video above. These are the playlists that started with every single thing we have said concerning all the theories of law, as well as that of the meaning of law. Watch those videos and see how that helps you. I will also see you next week. Remember to subscribe to this channel and also share with your friend. Goodbye as I proceed to meet you next week.